Hope you're all doing well. Last lecture, I'm sure you're as excited as I am. I'll be talking to all of you soon, trying to give you some guidance on where your grade is, what it would be if you took the exam, or what you would be if you didn't take the exam, and see what you would need to get on it if it's worth your while to even sit for the final. But it is an option you have. And some of you may even consider doing pass-fail, so that's something you can look at. So we're going to talk about commercial liability insurance for businesses. Again, if you are in business, you're going to be a manager someday, this will be really important for you to understand the types of coverages that are needed to run your business. With that, I'm going to share my screen. Just give me a moment. I'm probably going to have to go out and open the slide. Hopefully you can see this. So liability coverages. I have a slide real quickly to run down all the types of things we're going to cover. It's a quick reference. Here's a summary of all the types of liability coverages most organizations have. First of them is just an overall general liability policy. We call those CGLs, commercial general liability. We also have something called employment practices liability, EPLI. That would cover, we'll cover in a minute, but that would be for you have a discrimination suit or you've done some kind of a practice that someone challenges. And so they're saying you didn't do it appropriately and they were harmed. Workers' compensation, we've already covered that in the past, but that is a policy most every organization is going to probably have to buy at some point. Commercial auto, we're not going to spend a lot of time on auto because it mirrors in some ways personal auto policies, slight differences, but obviously if you have a fleet of vehicles, you have to buy certain coverages for that. And it's different than a personal property or a personal auto policy because you're driving it and you have multiple people who can drive vehicles that work for you. If you're a business that owns aircraft, not everybody does, or maybe even own a personal aircraft that you use for business travel, that would be a separate coverage. Those typically are not covered anywhere else. And it also covers your liability for those passengers that are on the aircraft. An umbrella policy. This is going to pick up anything that you've not have enough coverage for. If it falls through the crack, it's really good to have an umbrella policy. It's kind of like a wrap policy, a difference in condition, but it sits across multiple policies. So we'll cover that. Professional liability. If you're going to be a CPA or an attorney or a physician, professional liability is so important, or an engineer. If someone challenges your professional opinion, you made a bad decision and your professional expertise was required, that would be called professional liability. Malpractice is the common term we use for medical professional liability. Errors and omissions is another type. So if I make an error or I forget to tell you something that you need to do, we call that an errors and omissions or E&O policy. Slightly different than a directors and officer, although it'll appear that they're similar. A directors and officers policy is going to cover someone who is in a management role. My title is Director of Risk Management. There's a lot of other directors in utilities. This is going to cover me as well as any officers of the entity. So your executive team, your board members that are considered officers, your CEO, your CFO, those are all officers of the organization. They make a bad business decision or they were negligent in the decisions they made, a D&O policy would cover them there. So real quick on the general liability, this would cover your legal liability. First of all, you have to be the one that's considered legally liable in order for you to have coverage. Someone can't just claim that you're liable. The insurance is only going to cover you if it's proven that you are the one liable to pay it. Could be anything other than auto and aviation accidents or employees' injuries. Why? Because auto would be covered under your commercial auto policy, aviation would be covered under your aircraft policy, and employee injuries would be covered under work comp. So if someone claims I got hurt on your business property, I got hurt or injured by the product you sold me, those would all be general liability type coverages. Most commercial businesses buy a package policy just like they do with property. We call that a commercial general liability policy. If you're a smaller business, you might buy a business ownership policy. We're not going to cover that in this semester, but just another type of liability policy. So what is covered? It's important to know that there's distinct differences on what's covered. First of all, anytime you are doing something on site or you're currently working on it, you're doing, let's say you are a construction contractor and you're building something for someone, even though it's not on your property, that is called premises and operations liability. If it's done, if the injury occurs on your premises or is incurred in the opportunity of you doing an operation for them. So it arises out of ownership, it arises out of maintenance, it arises out of business that you are doing at that point in time. You haven't created anything, you haven't finished anything yet, you are just doing day-to-day business. You also have something called products liability. So you sell something to somebody and they sue you. If you're in O'Reilly Auto Parts and you sell a part that someone's engine blows up, they put this alternator in and it was faulty and it caused problems with their engine, even though you didn't manufacture it, yes, they have liability. You sold it to a third party and they're going to sue you. You in turn can sue the manufacturer, but the whole point is that you have to have products liability coverage. There's something else called completed operations liability. So let's say you are that contractor still, you now have finished the job, you built them a building, you walk away, and 3 years later, the roof collapses. If they find out that the engineering or the construction was faulty or poor quality, anything that arises out of work that you previously performed, either on site or for someone else, they can be sued for that. That would be a completed operations liability. You also have contractual liability, where you're assuming the legal liability of someone else, either through a contract, oral or written. And then if you have contractors that you hire, there's something called contingent liability, which means that even though you didn't do the work, you hired them to do work for you, and you thus could be held responsible for that. You are contingently liable for what they do, their mistakes. Again, that commercial general liability policy is going to cover all of these things. It can either be an occurrence or a claims-made policy. I'm not going to get into the details of this other than depending on what type of policy you have, you can pick one or the other. One's more expensive. If you have an occurrence policy, you are going to, the policy that will cover your liability is when did the event actually occur. So someone slipped and fell on your business property in November of 2019. It occurred in 2019. If your policy expired at the end of 2019, it's still going to go back to that policy and say that's when it occurred. A claims-made policy, they come forth in January of 2020 and they say, I was hurt, I fell, I have my back injury is finally shown up. It's when they made the claim. They would go to that policy. So in that case, it would be a 2020 policy, not a 2019 policy when the event actually occurred. So depending on what kind of policy you buy, it would depend on how it's covered. 3 different coverages, A, B, and C. First one, bodily injury and property damage. This is where someone got hurt on your property or their property is damaged. So they either physically got hurt or the things that they own got damaged. The insurer agrees to pay on your behalf anything that you are legally liable or obligated to pay. The court orders you to pay somebody because they believe your injury is the reason, or your operations is the reason they got hurt, or your operations caused the damage to their property. Also, it doesn't spell out right here, but they also have to defend you. So they have to provide legal support. If someone makes some crazy claim that you are the reason that they have mental anguish and they've got stress and they've had to go to all these things, or if you have to defend yourself, your policy for CGL will cover it. Now, they're not going to pay the claim until it's proven that you're liable, but they will defend you. Like I said, it includes defense costs. They have the right to investigate the claim and to settle at their discretion. So if they feel like it's cheaper to just go ahead and settle out of court, they have the right to do that. There are a few exclusions. They're noted here just so that you're aware. If you're a business, so if you make an intentional injury, you physically harm somebody intentionally, that would not be covered. Someone could prove that. If you have a business where you are licensed to sell liquor, that's typically not covered. You can buy a separate policy for that. Work comp's not covered, we mentioned, because it's covered in a different policy. If someone claims that you discriminated against them or they were sexually harassed, that would be an employer's liability policy, covered in a different one. Mobile equipment, we just talked about earlier, that's probably going to be covered on an inland marine policy, so it wouldn't be covered here. We'll talk about personal and advertising injury. It's going to be covered in another section. So let's say so coverage A also includes fire legal liability. Let's say you are renting, you're leasing a property, your business operations is there, and so it's going to cover your liability associated with the business that you run, but you don't own the piece of property it's on. Coverage A will also cover the liability associated with the fire up to a certain amount. It's a limited amount, but it's saying you rented and what you did on your operations caused damage to their property. You have some liability there and it's covered. Coverage B, this is where those personal and advertising liability would be covered, not in coverage A, but coverage B. This means that your insurer will agree to pay anything that you're legally liable to pay that caused either a personal or an advertising injury. Sounds crazy. It's not physical injury to their body, and it's not physical damage to their property. It is, I've done some kind of harm to them that would be considered personal injury. You falsely accused and arrested them. Let's say they were shoplifting and you thought they were shoplifting and you hurt them in the process of arresting them, or you humiliated them and they later sue you. That would be a false arrest. That would be considered a personal and advertising injury. Slander, it's not listed here, but libel. You guys may or may not know the difference, but one is written, one is oral. So slandering somebody is usually oral, libel is usually written. If you violate someone's privacy, if you maliciously prosecute somebody, you evict somebody wrongfully, or you infringe on their copyright, those would be all personal advertising injury type items. Coverage C is very similar to auto and homeowners. Remember, you have the main coverage and then you have this weird small dollar value where someone gets hurt on your property. It's the slip and fall. I came walking in the door, you had a wet floor, I twisted my ankle and I need to go to the doctor. Medical payments is going to cover that, but it doesn't have a large value. They don't have to prove that you're liable. Remember, coverage A and B, you have to prove that you're liable for their injury or the harm that was caused to them in order for them to pay the claim. Here, they don't have to prove that you're at fault or that they were at fault. You just pay it. They do have to tell you that you have to return it in and claim it within 1 year, and they don't care about who's legally liable. Who's insured? It's typically going to cover the owner of the business, the spouse, if it's a sole proprietorship, because probably your spouse has some involvement. Now, if your spouse is doing something unrelated and they're running their own business out of your business, that might be thrown out. If you're a partnership, it's going to cover your partners or members and their spouses. If you're an LLC, cover any managers and members there. If you're a corporation, it's going to cover your stockholders, officers, and directors for these type of things as well. It also includes persons that are not named. So let's say you have volunteers that come to your organization and spend some time, and not-for-profit, and you have volunteers on site. They would be covered. If someone's acting in the scope of their employment, it's going to be covered, so they would be protected. If you die, let's say you're a sole proprietorship and you die, someone's going to have to come in and run things while your estate's being settled. They would be covered. There's generally an aggregate limit, and an aggregate means that's the most they're going to pay in any one period of time. So if you have some personal injuries under coverage B, and you have some medical payments, and you have some physical damage to somebody's property, all these add up, and the total cannot exceed the general aggregate. They may have a per occurrence limit, but then they also have a most they're going to pay in any one period of time. And then the products and completed operation, again, this is after you've sold somebody something and after you finish work for them, it has its own aggregate limit that's completely separate from the general aggregate. That's all I'm going to cover on that. So I want to cover the layers of insurance. So you buy CGL policy, let's say it's for $1 million. That would be, the first policy could be a primary coverage. This means they're the first company, insurance company, that's going to respond to a loss. If you have a $500,000 loss, it's in the scope of their limit. They're going to pay all the way up to $500,000. If it gets to the point where it exceeds that, you as a business can buy an excess policy, or we call that secondary coverage, where that excess policy would respond only after the first or primary layer has been exhausted. So that $1 million, they've run through that, and it's a $2 million loss. That excess policy would start covering at the $1 million level. There's also something where you have primary and secondary markets. We call that a quota share or prorated or pro rata program. That allows insurance companies, company A and company B, to share in the loss and the premiums proportionately. So sometimes you'll hear about a quota share program. And then the last one, I talked about umbrellas. So we're going to talk a little bit more about umbrellas, but basically umbrella coverage protects all of your underlying policies. So let's say you have a business property policy and you have a business commercial liability policy and you have a commercial business auto policy. As long as you have those underlying coverages, an umbrella will drop down and make sure it's protected, so that if there's not enough protection up to a certain level, it's going to cover anything, the gaps that are in between. So having an umbrella is really important. It provides some of that gap coverage, and it covers all policies that are underwritten in that umbrella. So in the next slide, it just talks about having that umbrella. It protects you against really catastrophic liability judgments. It's going to drop down and provide more coverage than if you didn't have that umbrella. When we ask contractors to work for us, and we know it's a big dollar job, we have our minimums for CGLs and auto. Maybe it's $1 million or $2 million for a CGL, and we say you have to have $1 million of auto. What we say on top of that, we want you to have a $5 million umbrella. That adds $5 million on top of the $1 million or $2 million coverages you have in place on the underlying. There are a few exclusions. It's not going to cover intentional injury, liquor, or liability out of professional services. EPLI, or employment-related practices, just a quick summary. So if you are in business and you have employees, obviously you can do something wrong. You can treat them unfairly. They can claim a lot of things, but an EPLI that protects you, let's say you didn't promote somebody or you demoted somebody and they challenged you. You terminated them wrongfully and they challenge you. They get an attorney and challenge you. They say you didn't hire someone, that you were negligent in your hiring process, or you retaliated against one of your employees. You forced or coerced one of your employees to do something that was unethical or unlawful. They could turn you in for that, an ethics hotline. If you were harassed at work, if somebody slandered, spoke, but wrote something bad about you, maybe you have a bad review, so that libel, which is a written falsity, maybe they put that false statement in your employer review and you want that retracted. And any other work-related abuse that would fall in here. It does also provide legal defense, so that is included in the policy limit. The claim, however, unlike the CGL where the insurance company can claim, settle at any time, that cannot be settled without your consent on this. The reason is because your reputation is on the line. You don't want it to get out that you discriminated against somebody if you really felt like you didn't, and you want to actually fight that just based on the principle of it. Things that are excluded from EPLI are any criminal acts, like those ethical things that are, obviously very much break the law. Ethics are a little bit more gray. Anything related to contractual liability or workers' comp, those would be covered somewhere else. And the reason this is important for you guys to know is what we're seeing is a lot of employers are adding a lot of additional EPLI practice insurance that they didn't have in the past. There's a lot of the Me Too movement, a lot of discrimination suits, a lot of sexual harassment suits that are coming up as a result of that. Work comp, I'm not going to spend a lot of time again. Remember, work comp is going to cover your medical expenses, your death benefit, some temporary income while you're off, and any rehab that's needed as a result of a work injury. If it's work related, it doesn't go on your health plan, it's going to go under work comp. And you do not have to prove fault. That's why you have work comp, is because you don't have to prove fault. If you're an employee of that employer, it's job related work, they are liable regardless of fault. They agreed to pay everything. There are no policy limits. Basically, it's going to look at the state law, and if the state's law says it's unlimited, your insurance carrier has to provide unlimited under that policy. Coverage is needed in some states, even where it's not required for smaller employers. So in the state of Missouri, you have to have at least 5 employees to be required to have work comp. But we do not require work comp for our, we do require, I should say, work comp for some of our contractors. They could be a 3-man show business. We're going to make them have work comp because we don't want that contractual liability to come back and bite us if one of their employees gets hurt on the job. If they don't have work comp coverage, we may end up having to pay their lost wages and their medical expenses, which we don't want. Okay, commercial auto, we know what auto is. The only thing I'm going to point out is there's 10 different classifications. So like with businesses, there's a lot of vehicles. People can be using a fleet vehicle. They could be using their own personal vehicle to do work, so they have some coverage there. They could be renting vehicles, owned, non-owned vehicles. Those are all covered on a commercial auto. So you have different classifications. We're not going to get into them in this class. It does have some liability coverage as well as physical damage. So you could have physical damage to one of your fleet vehicles or company cars. It also is going to have liability. So if you harm, one of your employees is driving and they hurt somebody else in the other vehicle, that would cover them as well. And you can always add on towing and other labor costs if you choose. If you are a garage operator, let's say you're an auto dealer, obviously that's a little bit unique. You can't use these policies because they actually have more liability, so they actually would be more expensive and have different risk profile. So garage coverage is different. If you have, as a garage keeper, you probably have legal liability for anything that's in your possession. So if someone drops off the car and you are fixing it and their vehicle gets stolen or damaged while it's on your property, it would cover you. Aircraft, very rare. Just want to mention that it's highly specialized coverage. Most people don't have it, so it's specially underwritten, and there's very strict rules about how people are licensed, and so they have to look at your qualifications, that you're healthy and you've had medical reviews. There's a lot of things that go into getting aircraft coverage. Just to note, most major airlines generally buy a minimum of $2 billion of liability coverage on their jets. And if they have one plane crash with several hundred passengers, it can be very costly. Professional liability, we talked a little bit, but if you are considered a profession and you have not done your job properly, let's say you're a doctor, a dentist, and you're going to have a malpractice or omission type injury, you failed to do a test, or you failed to recognize something, or you failed to educate me on what I needed to do, someone could claim that you were negligent. The injury from a malpractice perspective has to be the result of a medical incident. Can't be that advertising, you said something bad about them, that wouldn't be covered. Anyway, so it covers not only the physician, but sometimes they have people working for them. So if you're a doctor and you have nurses or CNAs that work for you, any negligence that you are directing them to do would be covered. Oh, thing to note, the forms permit the insurer to settle a claim without your consent, so because they can become pretty expensive pretty quickly. Errors and omissions. So this protects against loss that occurred, that a client incurred because you did something negligently, you failed to do something, or you just made an error. Typically, these type of E&O policies, which is another type of professional liabilities, are bought by people such as insurance agents or real estate agents, stockbrokers, attorneys, consultants. They would be, instead of having a malpractice type, they're going to have an E&O type insurance. Same type of thing. They were negligent in what they did in their profession. Directors and officers is slightly different. It provides financial protection for any director, a manager in their role, executive committee member, officers of the corporation, if they are personally sued for mismanagement of affairs. I personally believe that the D&O coverage is going to go up substantially after COVID, because a lot of people are going to question decisions that are made by executive managers for failing to protect them, for them feeling unsafe at work, those type of things. So a lot of people should be buying more D&O. But what I've seen, the trend right now, I don't know if you guys watch headlines in insurance, but Tesla recently decided to drop their D&O coverage. And some other investors said that's, we have to have an alternative to cover us. So as soon as you drop that coverage, and if you're a board member, you're not protected personally for making a decision. You don't want your own personal assets on the line. You're going to make sure that this coverage exists if someone sues you personally for a business mistake. And if you're a manager, you're going to want that protection, because everybody makes mistakes. Someone can claim something that's a mistake, or you did something inappropriately, even if it wasn't intentional. So you want to make sure that you have protection. It does exclude bodily injury and property damage. Basically, it's protecting, it's not covering the bodily injury or property damage itself. It's what negligence you incurred, they incurred, from your negligence. And that's all I have. That is it for all 4 of the lectures for this last few weeks. Soon I'm going to be setting up a review session later next week, and I'm also going to be putting together the quiz and getting with each of you. I'll probably set up, send everyone an individual email of where they stand in the class going into that final week to see if it's something you're interested in taking. So I will talk to all of you very soon, and hope you're well. Hope you enjoy your weekend. Take care of yourself, and we'll talk soon. Bye.